Every single gun law decided in this country since June of 2022 has to answer to one Supreme Court ruling, and if you don't understand what that ruling actually said, you don't understand why courts have been striking down and upholding gun regulations in ways that might seem completely inconsistent ever since. New York State Rifle and Pistol Association versus Bruen didn't just decide one case about one state's permit system. It threw out the legal test every federal court in the country had been using to evaluate gun laws for over a decade and replaced it with something completely different, a test built entirely around American history rather than modern public safety analysis. Every ruling you've heard about since, laws struck down in Hawaii, laws upheld or struck down involving domestic violence, restraining orders, fights over marijuana users and firearms, arguments over age restrictions for buying a handgun, all of them trace their legal DNA directly back to this one case. If you've heard the word Bruen thrown around in every gun rights headline for the past 4 years, without ever getting a clear explanation of what it actually changed, this is that explanation. I'm going to walk you through exactly what New York's law required, why the Supreme Court found it unconstitutional, what specific new legal test the majority created, and why this single case is the reason almost every major gun rights ruling since 2022 in states from Hawaii to Texas ultimately traces back to this one decision. Before we get into it, if you want to actually understand the legal machinery behind gun rights news, instead of just reacting to headlines, subscribe and turn on notifications right now. Bruen is the single most important gun rights case in a generation, and understanding it is the key to understanding almost every major Second Amendment ruling that's come since, the foundation everything else in this space gets built on top of. Let's get into exactly what New York's law said and why the Supreme Court tore it apart. Here is what New York's law actually required, because understanding the specific mechanics is essential to understanding why the Supreme Court found it so constitutionally troubling. New York had what's called a may-issue permit system for carrying a concealed handgun in public. To get a license, an applicant had to demonstrate proper cause, a specific, legally undefined standard that New York courts had interpreted to mean something beyond an ordinary generalized desire for self-protection. In practice, this meant an applicant needed to show something like a specific, documented threat against them personally, rather than simply living in a high-crime area or wanting to be able to defend themselves the way any American might. Licensing officials had broad discretion to decide whether an applicant's stated reason actually satisfied this vague standard, which meant two people with nearly identical circumstances could receive completely different answers depending entirely on which official reviewed their application. Robert Nash and Brandon Koch, the two individual plaintiffs at the center of this case, both applied for unrestricted concealed carry licenses in New York, and both were denied because state officials determined their generalized concern about safety didn't rise to the specific, particularized need the proper cause standard required. Represented by the New York State Rifle and Pistol Association, they sued, arguing this entire licensing framework violated their Second Amendment rights. The first segment of this story is the legal test the Supreme Court actually threw out, because understanding what changed requires understanding what came before. Since the court's 2008 decision in District of Columbia versus Heller, which first recognized an individual right to keep a firearm in the home for self-defense, lower federal courts had developed their own two-part framework for evaluating gun regulations. Step 1 asked whether a law regulated conduct falling within the scope of the Second Amendment as historically understood. Step 2, if the answer was yes, applied a means-end scrutiny analysis, essentially balancing the burden the law placed on the right against the government's stated public safety interest, similar to how courts evaluate many other constitutional rights. Nearly every federal circuit court in the country had adopted some version of this two-part approach in the years after Heller, and it had become the dominant, settled framework for gun rights litigation nationwide by the time Bruen reached the Supreme Court. The second segment is exactly what the Supreme Court replaced that framework with, and this is the single most consequential part of the entire decision. Justice Clarence Thomas, writing for a 6-justice majority, rejected the means-end scrutiny step entirely, calling it inconsistent with how the court has treated other enumerated constitutional rights. Thomas drew a direct comparison to how courts handle the First Amendment, pointing out that judges don't ask whether a speech restriction serves a sufficiently important government interest balanced against the burden on expression. They ask whether the restriction is the kind the government has historically been permitted to impose. The majority argued the Second Amendment deserved the exact same treatment, a text and history-based analysis, rather than the interest-balancing approach lower courts had developed. In its place, Thomas established a new two-step historical test. First, courts ask whether the Second Amendment's plain text covers the individual's conduct, meaning, is the person part of the people the amendment protects, and are they engaged in something that qualifies as keeping or bearing arms? If the text covers the conduct, the court held the burden then shifts entirely to the government, which must demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. This meant the government could no longer simply argue that a law served an important public safety purpose. It had to point to specific comparable historical laws and regulations, generally from the founding era around 1791 or the Reconstruction era around 1868, showing that similar restrictions existed and were broadly accepted at the time. If the government couldn't find that kind of historical analog, the modern law would fail, regardless of how compelling the public safety argument behind it might be. The practical effect of this shift was enormous because it meant that decades of accumulated public health research, crime statistics, and policy analysis that governments had traditionally relied on to justify gun regulations became almost entirely irrelevant to the constitutional analysis, replaced instead by a search through old statute books and colonial-era legal records. The third segment is why the court found New York's proper cause standard specifically failed this new historical test. The majority opinion reviewed centuries of English and American history and concluded that broad restrictions requiring a citizen to demonstrate a special, individualized need for self-defense before being allowed to publicly carry a firearm had no meaningful historical analog in the American tradition. The opinion worked through several categories of historical laws New York and its supporting parties had pointed to, including Old English restrictions on going armed in a manner that terrified the public and various colonial and early American surety laws, and found that none of them actually imposed the kind of broad, discretionary licensing barrier New York's modern system created. The court found that while history did support certain limited, well-defined restrictions on carrying in specific sensitive locations, for example, it did not support a general licensing scheme that gave officials broad discretion to deny a permit to an ordinary, law-abiding citizen simply because that citizen couldn't articulate a threat more specific than the general risk everyone faces. The court explicitly stated that the constitutional right to bear arms in public for self-defense is not a second-class right subject to a different, more lenient standard than other enumerated rights, a phrase that became one of the most quoted lines from the entire opinion and one that gun rights advocates have repeated constantly in the years since, treating it as a kind of rallying cry for the broader argument that the Second Amendment deserves the same rigorous judicial protection traditionally reserved for rights like free speech or freedom of religion. The fourth segment is what the concurring justices added, because their opinions shaped how lower courts have applied Bruen just as much as the majority opinion itself. Justice Samuel Alito wrote a concurrence emphasizing the specific, narrow facts of the case, the two individual plaintiffs and their specific denials, seemingly trying to keep the ruling's immediate scope focused rather than sweeping. Justice Brett Kavanaugh, joined by Chief Justice Roberts, wrote a concurrence specifically emphasizing what the ruling did not do, making clear the decision did not prohibit states from maintaining shall-issue licensing systems, meaning systems that require an objective, standardized set of qualifications, background checks, training requirements, and similar neutral criteria, rather than the kind of subjective proper cause standard New York had used. Kavanaugh's concurrence went further, listing specific requirements, fingerprinting, a background check, a mental health records check, firearms safety training, that states could still lawfully require of applicants under a shall-issue system, providing states with something close to a practical roadmap for how to maintain a permitting process that would survive the new historical test. This concurrence mattered enormously in practice because it gave the 40-plus states that already had shall-issue or permitless carry systems a clear signal that their frameworks remained constitutionally sound. while signaling that the small number of states with New York's specific discretionary approach, including California, Hawaii, Maryland, Massachusetts, and New Jersey, would need to substantially rework their systems. Justice Amy Coney Barrett wrote a separate concurrence raising more technical questions about exactly which historical period, 1791 or 1868, should serve as the primary reference point for the historical analysis, a question the majority opinion left somewhat unresolved, and that has continued generating disagreement among lower courts ever since. Since laws and social conditions differed meaningfully between those two eras, and courts have had to make real choices about which body of historical evidence deserves the most weight. The fifth segment is the dissent, and it deserves to be presented fully, because it raised concerns that have continued shaping the debate over Bruen's practical consequences for years afterward. Justice Stephen Breyer wrote the dissent, joined by Justices Sotomayor and Kagan, arguing the majority's history-only approach ignored the practical realities of gun violence in modern America and abandoned the balancing approach that had allowed courts to weigh genuine public safety interests against the right to bear arms. Breyer's dissent opened with an extended discussion of the scale of gun violence in the United States, citing statistics on firearm deaths and mass shootings, a framing choice that reflected his broader argument that a purely historical test risks losing sight of the actual, measurable human cost the majority's chosen methodology would make harder for legislatures to address. The dissent specifically warned that requiring judges, who are not trained historians, to comb through centuries-old laws and determine which ones counted as sufficiently similar historical analogs would produce inconsistent, unpredictable results across different courts, since reasonable judges could easily disagree about how close a historical comparison needed to be. The dissent also argued that the majority's approach effectively froze gun regulation to what existed in a very different society, one without the population density, weapon technology, or urban environment gun regulations today actually have to address, making it structurally difficult for legislatures to respond to genuinely new, modern public safety challenges that the founding generation never could have anticipated, pointing specifically to the difficulty of finding a clean historical analog for challenges like assault weapons, high-capacity magazines, or ghost guns, none of which existed in anything like their modern form during either historical period the majority's test looks to. The sixth segment is why the dissent's warning about inconsistency turned out to be remarkably accurate in the years that followed, because the historical analog requirement has produced exactly the kind of unpredictable, difficult-to-apply results Breyer predicted. Lower federal courts across the country have reached genuinely different conclusions applying the same Bruen framework to similar laws, with some circuits requiring something close to a historical twin before striking down a modern regulation, and others applying a looser, more flexible reading of what counts as a sufficiently similar historical analog. One especially visible example came in a case involving a federal law disarming people subject to domestic violence restraining orders, where one federal appeals court initially struck the law down, reasoning that no sufficiently similar historical disarmament law existed from the founding era, a conclusion that struck many observers, including several sitting federal judges. As a troubling result, the historical test seemed to compel, even though it ran directly against overwhelming, obvious public safety logic. This inconsistency became serious enough that the Supreme Court itself had to step back in only 2 years later, in a 2024 case called United States versus Rahimi, specifically to clarify that the government doesn't need to find a historical twin, an identical law from centuries ago. Only a historical analog that is relevantly similar in both why it burdens the right and how much it burdens the right. The Rahimi decision, itself decided by a lopsided 8-1 vote with only Justice Thomas dissenting, effectively walked back the more rigid, twin-seeking version of the test some lower courts had adopted, while still preserving Bruen's core historical methodology. Even that clarification didn't fully resolve the underlying tension, and the same historical methodology question has continued surfacing in nearly every major Second Amendment case decided since, including cases addressing everything from domestic violence, restraining orders to drug users, to concealed carry rules on private property. Let's step back and name the single thread running through this entire case and everything that's followed from it. Before Bruen, courts evaluating a gun law asked 2 questions. Does this touch the Second Amendment? And if so, Does the government have a good enough reason for the burden it imposes? After Bruen, courts ask a fundamentally different question. Does this touch the Second Amendment? And if so, did something meaningfully similar exist and get broadly accepted centuries ago? That shift from a balancing test weighing modern public safety interests against individual rights to a historical excavation project searching for centuries-old analogs is the single change responsible for nearly every major gun rights headline of the past 4 years. It's why states with restrictive discretionary permit systems saw their laws collapse almost immediately. It's why some restrictions on where people can carry have survived while others have fallen. And it's why, 4 years later, courts and litigants are still arguing constantly about exactly how the test should actually be applied, a question the court has now had to revisit multiple times and will likely continue revisiting for years to come. It's worth sitting with why this particular methodological choice generated so much lasting controversy, well beyond the specific outcome in New York's case. Requiring judges to act as amateur historians, sorting through colonial statute books, Reconstruction-era session laws, and centuries-old court records to determine whether a modern regulation has a sufficiently close historical cousin is a genuinely unusual demand to place on the judicial branch, one that even judges sympathetic to expanding gun rights have sometimes struggled with in practice. Legal scholars across the ideological spectrum have pointed out that history is often messy, incomplete, and open to competing interpretations, meaning two equally careful, equally well-intentioned judges can review the same historical record and reach genuinely different conclusions about whether a modern law's closest historical ancestor is similar enough to count. That structural uncertainty hasn't gone away in the 4 years since Bruen was decided. If anything, it has become one of the defining features of Second Amendment litigation, with nearly every major case since forced to grapple with exactly how demanding the historical analog requirement should be. If there's one thing worth taking from this breakdown, it's that Bruen wasn't just a ruling about one state's permit system. It was a wholesale replacement of the legal methodology every court in the country uses to evaluate every gun law. And that methodology, built entirely around historical analogy rather than modern balancing, is the reason gun rights litigation has looked so different and so unpredictable in the years since. Understanding this one case is the foundation for understanding literally every major Second Amendment ruling that's come after it, from the domestic violence restraining order case decided 2 years later, to the marijuana and gun ownership case, decided this past summer, to the Hawaii private property carry case decided the same week. If this helped you understand the case behind the headlines, share it with someone who's heard the word Bruen constantly without ever knowing what it actually did. Subscribe so you catch the next major ruling that traces back to this one, and I will see you in the next one.